Because I won't take any more time. I've already been told that I'm arguing against my own side in a way. So I'll just stop with that. In that small compilation I've given your lordship, the last two are just Mr. Palkiwala's articles. Your lordship may see it.
We the people, or we the nation.
Yes, we the nation. I'm most grateful. Most grateful.
Thank you. Who comes next?
Please. Lord, I have prepared a compilation, Lord, which contains, Lord, the written submission which I already filed.
What it means is that every succeeding council is again, giving us compilation after compilation.
So, Lord,
That makes our task difficult. But not that I am opposing or coming in there.
I am not giving, Lord, 60 pages or 100 pages.
How do we respond?
Solicitor General gave us.
We respond.
He took us by surprise. Lord, to cut short our, Lord, submissions. What I have done is, Lord, whatever I have given earlier, I have made it as a compilation. It's not something new. The Lordship sees, Lord, annexure. 11 page, Lord, I'll tell you, Lordship. Lord, my written submission which was given earlier is annexure P.
Before you begin, the art of responding doesn't mean that you write down beforehand and down. When Golaknath was argued here, I am told,
Yes.
it was argued only for 3 weeks. And then the propositions were given by the council who opened, Mr. Arve's money. And when he reached point number 10, till then, that is till 1966, there were no written submission. When he reached point number 10, Justice J.C. Shah threw down the pen and said, now I am not going to write. I am not your steno. Please put it in writing. That's how it began. And now we have this.
And my Lord, on a lighter font, look at the font size.
Yes.
Then I know, my Lord, that there are less number of.
That had been
Lord,
asked in
so far as,
every learned council.
Yes.
That this insurance policy fonts.
but if I follow,
Difficult, sir,
if I follow Mr. Tushar Mehta, then I have to give him, Lord, at least 10 pages. I read
14, we said 3 pages and that was the outline. Now this is 14.
No, my Lord, this is actually, Lord, it contains the earlier one which you have already given. Then, my Lord, list of citation at page number, my Lord, 7, which you have already given. And rejoinder, my Lord, if your Lordship sees only, my Lord, 6 pages.
We will perhaps, I think, we'll have to take a call, whether we go by your original submissions.
No, my Lord, this is only a reply. My Lord, we are only, my Lord, we are giving a rejoinder, my Lord, to whatever we have made submission, because lot of submissions have been made. My Lord, this is not a case as Lord Ravi Verma said.
We'll again call upon all the councils.
Yes.
To put in the rejoinder submissions in not exceeding 3 pages.
Yes, my Lord. Lord, if your Lordship sees, greatly obliged.
Yes.
Lord, we want to
14, no? It's important.
You must also do some bit of homework rather than
Yes,
put it pure.
Lord, this,
I
yes.
have not tendered at that time. I have only a 3-page submission that.
Whatever, yes.
I have done that elaborated part of extracting the paragraphs from judgment and the rejoinder is.
Sarola,
at the end.
whatever you said
Together.
that day, the 3 pages exceeded that. So we have noted whatever you said, the paragraphs, everything is there.
Yes.
Your para
Because we've
102,
explained, if my
para
lords find it convenient, my lords may use it. If my lords feel that it's not necessary, my lords may not look at it. But for the purpose of convenience, it's tabulated, it's with footnotes, with paragraphs.
I'll I tell you one thing, Mr. Arora, with due respect. Yesterday I was looking at one of the judgments of this court, Pramati. Pramati is a 48 paragraph judgment. 283 pages just have gone into these written submissions.
Yes, that's correct, my lords, absolutely. My lords, we had judgments, if my lords will look at the earlier years, only in 6 pages or 8 pages and laid down the full.
Look at Champakam Dorai Rajan, just
And
about
then,
4 pages.
my lords, Indira Sani was like a volume and then others were a volume. So my lords, we have also kind of evolved accordingly.
Goes in argument, 40%.
Lord, in fact,
We have not
Lord, as Mr. Ravi Verma said, Lord, this is concerning, Lord, the whole lot of population.
Very well, let's not waste time, sir. Go ahead.
Lord, Lord should kindly see, Lord, this amendment 103, Lord, constitutional amendment, Lord, puts us a status quo ante. What, Lord, the reservation brought, Lord, so far as, Lord, the oppressed and depressed class, Lord, recognizing, Lord, that they were kept away from the mainstream to offset, Lord, the social discrimination and, Lord, to see that the inequality is being taken away. Now, Lord, this 103rd constitutional amendment, Lord, puts really, Lord, us back, Lord, to the pre-constitutional stage. Lord, in fact, the Indira Samani case itself clearly says, Lord, any reservation on economic criteria, my lord, will lead to a virtual deletion of Article 15.4 and 16.4. That was a caution struck, my lord, not, my lord, simply, my lord, there was any observation. There was a EWS, my lord, reservation given on the basis of an office memorandum, but what was interpreted, my lord, is Article 14, 15 and 16. My lord, that is what I wanted to remind, my lord, this bench. That, my lord, only to uplift, my lord, the poor, my lord, this reservation is brought. Lord, there is no dispute. But the question is, my lord, can they be uplifted, my lord, through this reservation? Lord, the answer, my lord, is an emphatic no, because reservation, my lord, is not a poverty alleviation program. Lord, that has been already decided. And, my lord, indigence also is not a basis for reservation. Lord, one important document, Lord, which the Solicitor General and Learned Attorney General relied upon, Lord, is Sino Commission. Lord, in fact, Sino Commission, Lord, did not support them at all. Lord, if your Lordship, Lord, I have gone through the Sino Commission thoroughly. Not only Sino Commission, Lord, and also this NSSO report. If your Lordship sees, Lord, the Sino Commission itself did not recommend for any reservation. The Sino Commission said that if you want to give reservation on the basis of economic criteria, then abolish all type of reservation and give reservation on the basis of economic criteria for all of them, irrespective of caste, creed and religion. Lord, that is the observation, Lord, that I have even mentioned, Lord, page number 695 and 696 of the convenience compilation. Much is said about the Sino Commission, Lord. In fact, Sino Commission, Lord, has not supported their arguments at all. Lord, paragraph number 8.6 to 8.9, what they have said is, Lord, they have said target welfare schemes to bring in for EWS in the FC category. That is what, Lord, the Sino Commission has said. Lord, in fact, Sino Commission, Lord, has gone to the extent of even saying that there is no data available, Lord, so far as the economic backward class is concerned. They have said it in categorical terms. Lord, I have said that, Lord, in paragraph paragraph E, Lord, 1E, it's at page number 712. Lord, in fact, the Sino Commission itself has recommended to conduct socio-economic surveys of economic backward classes within the forward caste. Lord, that is at page number 711. That, Lord, page 711. Sino Commission has gone to the extent of saying that, Lord, there is no empirical data so far as the economic backward class are concerned. Therefore, Lord, in absence of, Lord, empirical data, Lord, reliance of Sino Commission, Lord, at page number 24, Lord, on the basis of one NSSO survey, and, my lord, which has been relied by the Attorney General, my lord, to say that 31.2% of them are, my lord, poor from the forward caste is concerned. Lord, my humble submission, my lord, that data itself is wrong. Why, my lord, I am saying that data itself is wrong is, I have gone into that NSSO data, my lord. In fact, I have given even the, my lord, where it can be downloaded. That NSSO data is nothing but, my lord, it's a household consumer expenditure, employment and unemployment data. The survey was conducted, my lord, on 1,24,680 households in 7,999 villages. And, my lord, no, my lord, survey was conducted on social status. My lord, in fact, if you also see, my lord, H, I have clearly said H. NSO data is for different purposes. reliance for identification of backward class, nowhere this NSSO speaks about economically backward classes or economically weaker sections. In fact, they themselves admits that the social group which they meant is they used to do a random sampling, walk into some house, ask one person, head of the family, and then collect the data. That is what they have said. Now, do they reflect the entire family? Your Lordship knows in an entire family, economic condition varies from each and every one. My brother may be rich, I may be poor, and my younger brother may be in a different category. But that is the data which they have collected, and they themselves have said that these are all the data which we have collected. Therefore, my humble submission would be, so far as reliance of the Sino Commission, and the data, which it relies upon NSSO, is not going to help them in any way, for bringing in this reservation. The knows for any sort of reservation, this court has been, very categorical that you should need an empirical data. When Sino Commission itself admits that we don't have any empirical data insofar as the economic backward class is concerned, how will you justify your economic weaker section data is concerned? Because your affidavit, your counter affidavit, your arguments, everything relies upon the Sino Commission. Sino Commission, in fact, relies upon NSSO, and NSSO makes it very clear this is not one which relates to a social status or for a EWs, C or for a backward classes. That's what it's very clear. Then, my humble another submission is about the compartment theory. One of the arguments of learned Advocate General is that, Attorney General is that, this is a watertight compartment. The reservation is given insofar as the one compartment, they can't seek reservation from the other compartment, and the 10% they say, is an exclusive reservation so far as the forward caste is concerned, that is EWS. My humble submission would be, this compartment theory, enunciated by learned Attorney General, cannot be correct because your Lordship knows, the backward classes or the scheduled class and scheduled tribe, they can even compete in the open category. In fact, I have given the citations also, I will not trouble your Lordship by reading that. Then, your Lordship knows that your Lordship can see, the two judgments, Samatha Andolan Samiti, as well as this Thirupari Saran, where they say that competing in the open category, they can't be even counted in the reserved category. That is what it says. Therefore, this open category is meant for all. It cannot be counted towards their quota. Now, one of the argument is that extraordinary situation arises. What is extraordinary situation? Now, if a Lordship sees Sino Committee, they never considered or dealt with an issue of an extraordinary situation. Or, the bill has dealt with an extraordinary situation. In fact, due to the economic growth, the poverty has reduced. In fact, after the judgment of Indira Savani, the judgment in J.C. Lakshman Rao Patel, they have made it very clear, what is that extraordinary circumstances? They mean, cut off from the mainstream. Here, they are already in mainstream. They are already in mainstream. That is what the finding of Indira Savani's case. And where is the question of, the extraordinary situation being raised? Therefore, my humble submission would be, that argument, of extraordinary situation as arisen is only, on the air. It cannot be seen in paper, no data, nothing. Sino Commission doesn't say so, bill doesn't say so, and therefore, this argument, cannot be accepted. This Sino Commission was very mysterious, I should place this, because this is the order of this court, I'm going to take your Lordship, how the Sino Commission surfaced. Yes.
You have limited time.
Yes.
Why?
I have said, yes, I have said why it was kept, as a secret document. I have given the page number also, this court has recorded that, in another case. I will not trouble your Lordship, by saying that. In fact, the arguments, that it is a reasonable classification, all that, they are not able to meet out. In fact, we have even said the width power and the guided power test violation. We have also said about that. If your Lordship sees point R, in fact, there is a categorical observation in Ashoka Kumar Thakur, that, my lord, inclusion of forward caste, my lord, and reservation violates the basic structure of the constitution. My lord, there is a categorical finding, my lord, by the constitutional bench, in fact, my lord, that extracts the Indira Savani 2, my lord, observations also. My lord, in fact, I have, my lord, given data in Annexure C as to how, my lord, this rightful share in government jobs, my lord, is still a distant dream. And, my lord, the persisting rampant discrimination is happening, my lord. If your lordship sees Annexure C, my lord, from page 15 to 26, my lord, I will only show, my lord, one data, my lord, that is at page number 18. The lordship can see this data. It is, in fact, the right to information, my lord, news item, my lord, reflected in Hindu, my lord, at page number 18. Your lordship can see, my lord, what is the percentage of, my lord, the officers, my lord, in OBC concern, my lord, in the government department. In fact, Group A is 14%, Group B is 15%, C is 17%, D is 18%. In fact, my lord, one data also says, you should kindly see, my lord, page number 16. Not even a single person, my lord, is in the President's Secretariat, OBC cadre. That is what it says, my lord, in page number 16. Then, my lord, you should kindly see, my lord, the other arguments where, my lord, the double reservations and all, I don't want to go, my lord. In fact, it is not a double reservation. My lord, open category, my lord, if they come and compete, my lord, that cannot be counted as a reservation at all. Lord, my humble submission would be this: 103rd Amendment, Lord, is not a mere violation, but it is an abrogation of the constitutional core values. Then, so far as, Lord, the learned Solicitor General, Lord, submission is concerned, Lord, my learned friend questions as if, Lord, there cannot be any judicial review. Lord, Lord, in so far as the constitutional amendments is concerned, Lord, he would say, unless, Lord, the chair, legs of the chair is broken. Lord, we are demonstrating, Lord, to your Lordship, that, Lord, the edifice of our constitution, Lord, is built upon and stands on several, Lord, pillars. Remove any one of them, the constitution collapses. Lord, in fact, if your Lordship sees, Lord, the language of the preamble, well, that was taken from the resolution itself, Lord, the resolution, your Lordship knows, Lord, it is a resolution adopted on 22/1/1947. Kindly note down, my lord.
Yes.
That resolution, one of the resolution, clause 5, is equality and equal opportunity. Now, whether that, Lord, can be removed, Lord, this is considered to be a basic human rights. Lord, equality is considered to be a basic human rights. Lord, along with the liberty. Lord, they are essential features of constitution.
Yes.
Now, my lord, if this edifice, one of the, my lord, pillar is removed, my lord, what are all, my lord, the edifice of the constitution, what are the pillars, my lord, I will just name, my lord, I leave it to your lordship, my lord. So far as first one is concerned is sovereign democratic republic, then justice, social, economic and political, then liberty of thought, expression and belief, faith and worship, equality of status and opportunity. Now, each one of them, Lord, is important and collectively they assure the way of life to the people and which the Constitution guarantees. Lord, this is the undertaking where, my Lord, the people have come together. Now, today you wanted to remove this. Lord, we have one anomaly, my Lord. That is what I wanted to show your Lordship, my Lord. In Tamil Nadu, your Lordship kindly see Annexure D, my Lord. In Tamil Nadu, kindly come to Annexure D. Lord, these backward classes, page number 27, Annexure D. Lord, these backward classes, Lord, have not been still included, Lord, in the union list. Now, what will happen to them? They are the reserved candidates insofar as the state is concerned, but till today, my Lord, they have not been given reservations, my Lord, insofar as the union list is concerned, and they cannot compete, my Lord, in the central government jobs. Lord, that is why, my Lord, I say, my Lord, that equality still prevails.
Going by the submissions made by the Learned Council, if they happen to be in that EWS category, they will certainly be entitled.
Lord, that is what, Lord, they will say, my Lord, that it will go into the EWS category. But if your Lordship sees, Lord, that creamy layer also will come into force. Lord,
Creamy layer will also be entitled
Yes.
in the open category of 40%.
yes, Lord, I just pointed out, Lord, what is the difficulty.
But that
Yes.
argument doesn't take us further.
Yes, Lord. Now, my Lord, if your Lordship sees, Lord, I will skip that, my Lord. Now, if your Lordship sees this controlling article, I'll come to this controlling article. Lord, I was talking about.
Mr. Wilson, you are eating into everybody.
No, Lord, I am not, Lord, still I have 10 minutes more. Yes. Yes. Lord, so far as I'll finish, I'll complete it, Lord.
Yes.
Lord, so far as this 8 lakhs criteria is concerned, Lord, how there is no controlling. Lord, in fact, this Honorable Court, Lord, has recorded as the events, Lord, how they came out with the office memorandum and how the writ petition, Lord, came before this Honorable Court challenging that 8 lakhs criteria. Lord, I've said in paragraph G, H and I, Lord, in fact, Lord, if you also see that 8 lakhs category, page number 28 in 14 different states, I've given that. Lord, they have adopted.
Wilson, these are all facts.
Yes.
You can't get into that.
Yes.
You talked about identity width.
Yes, identity width and Lord, they are, Lord, certainly, Lord, they are, Lord, trying to, Lord, take away, Lord, the identity.
Thank you,
And,
Mr. Wilson.
and Lord, the comparison alone, Lord, I've showed to you, Lordship, the comparison.
In
That-
facts, we can't strike
Yes.
a constitution.
Greatly obliged, Lord. Lord, but why I'm saying is that, Lord, these things have been gone into, Lord, by this Honorable Court, Lord, in earlier round of litigations have said that is, Lord, unconstitutional and it affects the basic structure of constitution. Lord, greatly obliged. Only one thing I have to say, my Lord. Your Lordship gave us a good hearing. Lord, this was a pleasant bench. And, Lord, you treated us with utmost dignity and decorum. Lord, in fact, Lord, I would even appreciate that there is water to drink and quench our thirst. Greatly obliged.
Thank you.
My lords, I will try and be very, very fast and swift. My lords, this contains my original submissions. The last 4 pages are the rejoinder. Out of that 4 pages, it won't be even 2 pages because argument of the other side, as I believe has been addressed, has been put forward. So if my lords may just come to the end, there is a short rejoinder. It will be probably at page 25, just at the end. Please don't look at the first part. There's only one paragraph in the first part that I will advert to, maybe not even read. My lords have small on the rejoinder. Now, my lords, let me just put on issue by issue as has been urged by the other side, and I have my response there. My lords, as I understand, the learned Attorney General had put a proposition that SC/STs cannot be further subdivided. Now, he refers to Chennaiya in that respect. And he says, therefore, the question of giving EWS to SC/ST categories or for SEBCs does not arise. Now, then he says that if you give it, you cross the 50%. That is the argument that is advanced. Now, my lords, my response to this particular thing is that if we accept this proposition, then in that case, we can't even do a horizontal reservation because in all horizontal reservations, whether it is for women, disabled persons, children, wards of ex-servicemen, etc., it would amount to subdividing them within that. So therefore, I respectfully submit that that proposition does not meet the test. In horizontal reservation, we already have that principle of providing for that, and therefore, to say that it will subdivide may not be correct at all. Now, subdivision is proscribed in Chennaiya, and other judgments following Chennaiya are based on specific caste groups and therefore social. Criteria such as economic weakness are lateral, and there is no rationale to discriminate persons belonging to SEBCs, SCs or STs to not allow their participation. Now, my lords, I would request my lords, and I'm not going into the judgment, my lords have discussed at length the principles of horizontal and vertical reservation in my lord's judgment in Saurav Yadav. And this, my lords, will completely, as I put it, comes from that particular principle laid down there. Now, my lords, let me come to the second argument. The argument that was advanced was that basic structure doctrine, as in Indra Sani 1 and Indra Sani 2, and other judgments is of no relevance because they do not arise in a context of challenge to a constitutional amendment, and no basic structure test could have been employed while dealing with an office memorandum, which was the case in Indra Sani's case. Now, my lords, a paragraph from Bhim Singh judgment of Justice Y.V. Chandrachud, as it then was read out. First of all, that passage in Bhim Singh that was read out is actually an obiter. Number 2, that passage has been subsequently overruled in I.R. Coelho. Yes, it should be taken to have been overruled because, my lords, what has been said now is that in I.R. Coelho, that even the legislations which are put in the 9th schedule can be tested on the ground for violation of basic structure doctrine. And lastly, taking IR Queller and Madras Bar Association, my lords have held, particularly also in IR Coelho, march of law. So therefore, precedents and law that has been laid down by this court in Indira Sani is a legal position that tests the basic structure doctrine, and it cannot be said that merely because it was decided in the context of an IO, it cannot be said to be applied to the present amendment. I hope, my lords, I have made myself clear, because and my lords will find this Madras Bar Association paragraph extracted here at page number 18. It's only for the convenience of my lords. I've extracted that particular paragraph at page number 18. It's the last few sentences of that paragraph, about 10 lines from the bottom, which lays down the structure after recording arguments on both sides. Now, my lords, therefore, my submission will be that Indira Sani 1 and 2, more particularly 2, is required to be treated as a voice of this court, and there is nothing that warrants overruling of the same, or to say that the guidelines, principles laid down in Indira Sani will not apply to the present amendment, merely because that was an OM and here it's an amendment to the Constitution. It's the principle. Now, my lords, coming to the next. My lords, it was debated across and also urged by, I believe, by the learned Attorney General, that alternate facts and figures cannot invalidate a constitutional amendment, and this court cannot go into facts and figures for the purpose of invalidating. My simple reply to that is, my lords, it's a very well settled principle that the test of constitutional viris is dependent upon its impact of the state action. It's not based merely on the statement of object. How it impacts, finally, is the test that my lords will apply to test the constitutional viris. Now, it will not be merely because it sounds that very well we are providing. So, my lords, the facts and figures that have been placed before this court will go to show that the impact of this particular state action actually affects the constitutional, it actually affects basic structure doctrine and has an impact which cannot withstand the scrutiny of this court. Now, my lords, it goes to the very core idea of the equality. That's the principle. Now, my lords, the learned Solicitor General, and I think this is an important response that we need to consider, and it was also argued by my learned friend Mr. Gopal Shankar Narayan, as I heard it just now. It is suggested that not all incursions into the basic features destroy the basic structure of a constitution. What was said was that the alleged breach of basic structure is not a mere violation unless it is shocking, unconscionable, unscrupulous travesty of quintessence of the Constitution. My lords, please put it on a test. If this proposition is accepted, then you can go ahead, hit the basic structure of the Constitution chip by chip. Go at it chip by chip. It's not shocking. It is small. You'll have a next one. Now, where this principle comes from, if my lords may just give me the benefit at page number 21 of my submissions. And my lords, I just have very short ones. I'll finish with this very quickly so that my friends have an opportunity and I don't eat into their time. My lords, the principle comes from what is called page number 21, paragraph 19.1, about third line. The principle that comes here is from the ship of Keyser's paradox in philosophy, offers a relevant parallel. If over a period of time, every single part of a ship is replaced by a new part, at what stage does a ship become a new ship? And therefore, if we accept this proposition, then it's not shocking. It does not affect. It is something very small. And we can go at it slowly, chipping away. We will one day do not know whether the ship is new or it was what was expected by this court on the principle of a basic structure doctrine. So, my lords, I would respectfully submit that a proposition of that has to be taken with utmost caution and utmost restraint, if I may say so. Now, my lords, I come to the next submission, which is made by a colleague, learned Solicitor General. The primary argument that is said was that the constitutional does not allow for migration of SC/STs, who are the most backward, to vertical reservations created for SEBCs, which are relatively less backward. Now, constitution can create another zone of affirmative action, this is the argument, for EWS category which exists outside the fold of pre-existing reservation. My lords, I would respectfully submit that first of all, we are not here in this matter and we have not tested that principle of migration of SC/STs into the OBCs. There is no argument that is advanced. It is an area that should be left at the time when there is an issue that is raised. Having said that, in any case, in R.K. Sabharwal and down the line, my lords have recognized that while there is reservation for SC/STs and OBCs, that does not prevent them, whether it is under 16.4 and 16.4a, to move into the general categories if they are so meritorious. Now, if migration there from the reserved category to the general category is permissible, now this is taking back to EWS, which excludes other than classes mentioned in clause 4 and 5 of 15 and 16, apply the same test then there. Please consider it that we are then, people are only, there is a limited, I have already argued it, I'm not reiterating. Proportionate reservation is never envisaged under 15 and 16. Only area where proportionate reservation is envisaged, and I think there my learned friend should have pointed out, Mr. Gopal Shankar Narayan, is under 343T and 343D. That is where reservation for scheduled caste, scheduled tribe is proportionate to their population in a constituency, but not under 15. Now, if they are not proportionate, their representation within the reservation class is small and limited. There are many which are left out. There are many which are left out, which may also be eligible under EWS. So therefore, to exclude them by saying that no, there is reservation for them, will be actually failing the test and failing even the test of R.K. Sabharwal, which recognizes that you can be considered under the general category. Now, my lords, very, very quickly, there is an argument that is suggested that exclusion of EWS from EWS is not that of caste, but that of classes who are already receiving the benefit of a special provision. Now, my lords, in this, my reply is, this argument is completely fallacious in my respectful submission. The reservations have been made only for adequate representation and have not been given in proportion to their respective population for each group. Therefore, even within those classes receiving the benefit of reservation, the individuals within the same group, despite being recognized as backward, are unable to receive the benefit. There is therefore no justification advanced to discriminate against them, particularly on an economic criteria, which can only be a lateral consideration. Now, my lords, is just, I'm just moving on. Then, my lords, then there is an argument on a breach of 50% limit. My lords, I have in paragraph 24 dealt with it in detail. I'm not going to take the time of my learned friend, but here I have only one submission. Learned solicitor, one minute. Learned solicitor handed over this particular thing saying that there has been an increase of seats, etc. Please, my lords, we cannot forget the fact, whatever be the number of seats, the principle of reservation as envisaged under 15 will apply, and it is not the case made out by the government. So therefore, it will be 50, 40, whatever percentage will apply to these seats. So there cannot be that we have increased the seats, so therefore we have another 10%. Lastly, my lords, there is no mention under 16, whether there is a job opportunity. This is only in the education sector. This is my last point, and this is on the doctrine of severability. I accept the argument advanced by my learned friend on severability. I believe that if my lords were to uphold this, the deletion of the last portion, other than classes mentioned in clause 4 and 5, will serve the purpose. And this principle, my lords, it may not be reading down principle here. I have dealt with in my submission. It might be on a severability. And here, my lords, I place that judgment of Hiralal Hansora versus Kusum Hansora in the domestic violence case, where my lords applied the same test of severability
Thank you,
and
Mr.
deleted
Arora.
the,
Thank you.
my lords, can I have just one thing? Just one line, only one line. My lords mentioned about the guardrails for so far as the economic weaker section is concerned. Now, my lords, when the principle is a single criteria of economic backwardness or an economically weaker section, then that cannot be applied differently to different segments of the population. The guardrail is only one, economically weaker. There is no other guardrail. So, my lords, I leave it at
Thank you.
that. My lords, I am grateful. We are sorry if we are overshooting our time.
I am making 4 points very quickly. I'll try to finish it, my lord, in 5 minutes. My lord, we had seen, my lord, that the debates, parliamentary debates which are there, which I read out, and even the Constituent Assembly debates which are there, and the provisions, First Amendment, etc., clearly pointed out that as far as the economic criteria was concerned, was something which was excluded. It was not taken into consideration. Actually, I did not mention, but Granville Austin points out, my lord, that at one point of time when this was being drafted, then the economic criteria came in because the Chief Minister of Madras said that it should be included. But when it ultimately bill went, then the economic criteria was something which was not there. The sum and substance is, my lord, that when you look at the social, educational, and naturally, my lord, the economic criteria comes in. What Justice Jeevan Reddy points out is that the social backwardness, my lord, leads to educational backwardness and then economic backwardness. But assuming we reverse the position, my lord, then in the reversal also, it is not something that economic criteria alone can be there. Now that is something very important. The economic criteria, if you reverse the situation, my lord, as pointed out by Justice Desai, Justice Chennapareddy, even in that situation, it is necessary that the component of education backwardness and social backwardness, they come in. Because they form ultimately, my lord, as we saw the entire debates and discussions in several judgments, really forms, my lord, the equality clause. And that equality clause, my lord, is the basic structure. Ultimately drawing at that, and therefore if you have only the economic criteria, in my humble submission, cannot be the basis of the basis of structure, my lord, which sustains the constitution. So that's not my point number one. The second point is that because the idea ultimately is that you have the equal and unequals, and then you are trying to really see that the unequals strive to not achieve that kind of equality. The second point is, my lord, as far as the circles are concerned, I have little doubt about the circles because according to me, we cannot put them in, my lord, SC, ST in a smaller circle and then backward classes in the other one and then bring another circle. In my submission, my lord, there is equality, the overall equality which is one circle. In that circle we have persons whom we called initially the backward, because SC, ST and backward classes subsequently it was included because the term which was used was only backward. So within that circle, the idea is that ultimately they strive and achieve the equality. So therefore, my lord, these are two circles which are there, and the outer circle which remains, my lord, outside this 50% as we call it, is a circle which is general in nature. We cannot put it, my lord, that this is a circle and versus the other circle. This is generally for everybody. You cannot bring in any kind of reservation within that particular circle. If possible, what can be done is because that is something, my lord, the small circle is governed by 15.4 and 16.4, if you put it, my lord, that way. The other circle is 15.1 and 16.1, which is the equality clause read with 14. So in that circle, if you want to do something, what is permissible is the horizontal one. You cannot have vertical reservation in that. Because the moment you do it, then what Ambedkar pointed out, that you are virtually negating the entire principle, even of reservation, because 70-30 example which was given, that you keep on doing it and then the entire principle of reservation, etc. is nullified. Now, my lord, my third point, I think I mentioned this about that you can't have what London Attorney General argued, that 50% reserved and which is, my lord, one category and 50% is other, and therefore we are not touching that one. I don't think we can put it, my lord, as versus something that no, this has been done, and because we have given you everything, therefore we are giving it to other persons. It cannot be. And in one sense, my lord, if you do that, then it becomes caste-based reservation or communal reservation, which has been argued by Professor Verma. Now, my lord, my fourth point is, I'm rushing very quickly, my lord. The fourth point is about the creamy layer. Now, my lord, the question is that if we bring in this principle about the SC, ST, OBC, that on the basis of economic criteria, because 8 lakhs limit is there, 8 lakhs limit is here, and therefore you cannot distinguish or differentiate between the persons who are economically weaker. But the difficulty will be if you, as far as the SC, ST are concerned, because this creamy layer limitation doesn't apply to them, then that part has to be resolved. And that is not permissible if you bring persons here. I hope lordships are followed. That is to say that if you give the benefit, the criteria, economic criteria which is there, the cut of 8 lakhs, which is also creamy layer and here, their SC, ST are not governed by that. You bring them here, then that particular limit will come which cannot apply to SC and ST in that sense. The other argument is about Article 21A. That argument has been advanced because the definition includes, the SC, ST and backward classes. It's not merely the EWS criteria. Lordships must just note that page in Granville Austin, that is volume 4, 1530. I am not giving the pages, Indra Sani and other cases, but I am trying to say that shift the position from economic criteria to this one of social backwardness to economic criteria. Ultimately, the essential component of social backwardness, education backwardness should come, then only equality criteria and the basic structure we say will be something. What we have done is just pass on. Some questions which are put and answers which are in 3 pages. If your lordships will not wish.
Thank you.
Yeah.
Now don't read that, we'll read it.
I am very grateful, my lord. Quickly I summarized, but then I hope I was able.
Yes, Mr. Chauhan.
May I please, my lord?
Who follows after Dr. Chauhan?
Professor Mohan Gopal. My lord, I have only 2 issues which I want to agitate, my lord. First is, my lord, have taken a view that this is a constitutional principle. So the interpretation or the basis has been removed. So I have to see the constitutional philosophy of Article 141, read with Article 145(5) of the Constitution, my lord. As per the scheme of the Constitution, my lord, the precedent value of a judgment of this honorable court is decided, my lord. Whether it is a constitutional provision or a office memorandum or a order, my lord, when my lord have to test it from a different point of view, if my lord finally decides that this doesn't violate basic feature, my lord. So my lord have to respect the larger bench of Indra Sani, my lord, because that principle has to be respected and there should be discipline. Because my lord, in Nagaraj, when Nagaraj was argued, I have raised this issue, but Nagaraj was not referred to larger bench. Even today, after 16 years of Nagaraj judgment, in 2006, Nagaraj was decided. In almost all states, there is no reservation in promotion. And only central government, some services reservation promotion is being followed. So this should not happen, my lord, because the discipline, the judicial discipline of precedent and the bench composition or the hierarchy of the bench, my lord, that should be followed. This is my one argument. The second is, my lord, the learned Attorney General has said that the scheduled caste, scheduled tribe are loaded with so many benefits, my lord. So I could find a article, my lord, regarding American context, my lord. Professor Owen Fish, he has written an article, Accumulation of Disadvantages. So this article basically I want to read for a purpose, my lord, because he has defined that those people who have been historically disadvantaged group, they can only be classified. And their subjugation should be continued, my lord. And otherwise, it has many aspects, my lord, which will take time. So I want to just say that my lord have to see the historical context, my lord. the deprivation, social exclusion, the untouchability. Professor Ravi Verma has tried to say that scheduled caste should be bifurcated. When a president of India from the scheduled caste, he goes to a temple and he is not allowed entry. When they go to another temple, his wife was just pushed, and both the cases, criminal cases are going on for this. So what is the difference between a scheduled caste who is a laborer and who is a president? So my lord, have to consider all those aspects in mind, because this is a class of a different nature, and we don't want that this reservation should continue. But there should be some reason by which it could be changed. The reason by which the reservation system could be changed is to emphasize on caste, because the deprivation, the discrimination is because of caste, not because of his economic condition. If the economic condition would have been the basis,
Yes, go ahead.
if the economic condition would have been the basis, then this type of discrimination would not have been there. And my lord, other aspects I have already argued that social democracy and others. Now I think Professor Mohan Gopal.
Thank you. Who is there now next to?
Professor Mohan Gopal is
Yes.
sitting a little awkward because we have all reached into his time also.
So we started with Dr. Mohan Gopal.
Submission, my lord.
Sir, I do not
One
want
short
to
submission to
inconvenience.
No, that's all right. We'll go ahead for, how much time would you require?
Sir, Gopal, other than Mohan, namely Gopal Shankar Narayan, has taken up half an hour of our time unexpectedly. We did not know that. So I have no time left, sir. I want to make, I had a couple of substantive points to make, and there's no time for that. But your time is far more precious than mine.
No, please, we will try and accommodate, yes, to the extent possible.
I have only one singular submission to make, my lord, at the end.
Kalishwaran, Mr. Kalishwaran, please now.
Yes.
Yes, sir. Whatever you say, sir. I'm at your disposal.
Rather, Dr. Mohan Gopal,
Yes, sir.
give you half an hour after lunch.
Yes, sir.
After lunch, and that's the last word in the matter.
Yes.
Mr. Kalishwaran, whatever you wish to say, next 5 minutes, sir.
Yes, I can. Can I do it now, my lord?
Yes, right now.
Yes, my submission is only this, my lord. I just wanted to make a rejoinder with
Yes, sir.
respect to this already provided for argument, advanced by the learned Solicitor General and by the learned Attorney General. The already provided for argument, that is to say that you have already given the 50% is not a valid argument for two reasons. Number one, as Justice Bhatt was pointing out, the fundamental rights are always individualistic and it is not a class right. Therefore, to say that OBC or SC or ST is given the benefit of reservation as a class is not an answer when the fundamental right violation is alleged. Again, this was dealt with, this fundamentality or the individuality of the fundamental right was specifically dealt with in paragraph 108 of Puttaswamy, 2017, 10 SCC, page 1, at paragraph 108. But one single sentence answers it all. This is the sentence I quote. The individual is the focal point of the Constitution because it is in the realization of individual rights that the collective well-being of the community is determined, unquote. If my submission, therefore, Milo, is that if the benefit is given to us as a class, that is not an answer when we allege that in the context of exclusion, our individual fundamental rights are violated. That is the answer to that. Therefore, my lord, I would therefore also say that if in Puttaswamy it was said that if individual is the focal point of constitution, I would respectfully try to place with your lordship that what is focal point is also part of basic feature of the constitution. Therefore, this violation of individual fundamental rights can also be termed as an infringement or as a violence to the basic feature of the constitution. This is my submission on that. Secondly, very briefly, rather than coining it as an equality code, I would respectfully point out that the key test would be to see whether there is discrimination. That is to say, anti-discrimination will be at the core of the basic feature rather than the broader or rather the wider or rather the abstract category of equality code. The question is in the context of exclusion whether there is discrimination or not. But that will alone will answer the question. And lastly, would I just, in conclusion, I want to thank your lordship for streamlining it in such a fantastic way. And I am reminded of modulating the whole deliberation in such a fantastic, disciplined way. I am reminded of what the Times said about one of the novels by Gabriel Garcia Marquez. The sentence read like this, quote, "There is not one stale sentence, redundant word, or unfinished thought." Obliged. Grateful.